obligations under the health and safety framework. Also, we've seen ongoing litigation in relation to the use of the 90-day trial periods. It seems that the overarching obligation of good faith has meant that the courts have read in a number of obligations which aren't clearly spelt out in the statute. And the recent decision of Clark and Lighthouse ECE is an example of that, where there wasn't a link between the commencement date and the trial period, and the Employment Relations Authority found that the trial period was ineffective and couldn't be relied on. Now, despite what perhaps is perceived as an employee-friendly stance taken by the courts in relation to the protection of ongoing employment, a recent OECD report on the ability to hire and fire internationally has identified New Zealand as having fairly low standards. And the study assessed countries against a number of indicators, including notification procedure, statutory requirements for notice and severance pay, likely compensation levels, the possibility of reinstatement, and the limitation period for bringing claims of unfair dismissal. And on a scale of 0 being the least restrictions to 6 being the most restrictions, New Zealand scored 1.4, only ahead of America, Canada, and the UK.